My Lord, this matter was adjourned to this morning, particularly for plea taking and scheduling. And my Lord, we are ready to proceed with the same.
We are instructed file and have filed constitutional petition for the Constitutional Court. My Lord, that petition is number 31, 2025. Deals the number of matters, including questions of recusal, questions of referral, to the Constitutional Court. My Lord, questions of the continuation of the criminal trial in this criminal session case. My Lord, the declarations sought in that petition would impact this session case. Therefore, it is imperative that those matters be disposed first. Or in preference for this case. My Lord, in addition to the petition, we were also instructed and have filed a formal application which before this honorable court. Application is number 814, 2025. Eight 2025, in which we are seeking for orders stay, this court to stay the hearing of criminal session case V35. (2025) pending pending resolution of Constitutional Petition number 31 of 2025. My Lord, the application has not been formally served yet. But we expect to be able to do so today once the court endorses same. My Lord, it is our submission that that application be disposed of before any other proceedings. Session case 335 can take place. My Lord, for purposes of judicious disposal of the application, my prayer is that the same is fixed by you, my Lord, so that we can have it served, had, and determined. Have it today, have it determined.
I have been privy to the submission by learned friend Alibana. And my Lord, we are not aware of this extended application, nor have we been served. And my Lord, we were last in court on the 6th of November 2025, and it is almost a month since then. My Lord, we were prepared for plea taking and scheduling. My Lord, it is our prayer that this honorable court at this moment would this honorable court be pleased to have the plea of the accused persons first. And then, my Lord, since the defense has had almost a month to prepare for what they have just informed this court, the prosecution would similarly be pleased that we also be given adequate time to respond. In fact, first to be served, and then we can respond to whatever shall be contained in the application, my Lord. So humbly pray, my Lord.
Just to add on to the submissions of Council Karibala, two issues. The claim by the Assistant DPP that they are not aware of this application rather of the application and the petition is rather disturbing to us. See, yes, it's neither here nor there. My Lord, they seem not to have moved with the technological shift within the judiciary here, the judiciary system. With the digitalization of the justice system in this country, my Lord, they are presumed to be aware. By construction, they are aware of this matter. By construction. The application was uploaded on Equimis. It's there, and they know it. With all due respect, it would be imprudent for the assistant DPP and the entire team to appear this morning at 11 to argue out a matter of this magnitude without checking on Equimis. It's imprudent of them. It's routine, my Lord, these days. All of us, before we appear before court, we check even last minute, a few microseconds before we entered here, we had to check, is there any new development? And my Lord, once there is any document uploaded on the system, all the parties get notifications. And I'm sure if they checked their gadgets, the notifications are there. So that is a lame excuse. As I said, my Lord, with all due respect, it's laziness on the part of the assistant DPP. And that shouldn't be used as an excuse to come and pervert the course of justice. That said, my Lord, the last issue I wanted to address, my mind too, and the court, is the prayer they are making that despite the fact that there is a pending application for stay, court proceeds to administer retaking. That is the list that would come from the office of the DPP. I think it would be safer on their part, my Lord, to first address their mind to the gist of the petition. If a party seeks an order of stay, it's imperative, my Lord, that we look at the crux of the matter. In effect, my Lord, an application for stay is about arresting the proceedings. And the court is duty-bound to look at the reasons as to why the party is seeking to arrest the proceeding, halt the proceeding, bearing in mind the danger of proceeding to the next step before addressing your mind of the reasons being advanced. So therefore, it goes without saying, since they have not looked at the online application and they have not been physically served, so they don't know the issues that are being raised. And it would therefore be imprudent on their part again to ask to proceed in such a casual manner. My Lord, for the emphasis sake, as I conclude, had they taken trouble to look at the online pleadings, I am sure they wouldn't have made that prayer that we proceed, because these are very, very serious issues we are taking to the Constitutional Court. Actually, we have taken to the Constitutional Court. Very, very serious. Going to the root of the proceedings before you. Number one, the impartiality of this court. So anything that touches impartiality of the court is so central to the proceedings that court must be sensitive in taking any decision as to whether to proceed or not. The other issue, my Lord, with the question of the orders being sought of the removal of a judge. It's a very serious matter. My Lord, one needs to first critically reflect on those issues before you proceed to administer the plea. And these are the issues we intend to argue out in the formal application, my Lord. And I'm not attempting to argue them out, but I was just emphasizing the point that this is not a matter that should be handled in a cursory manner. Overlook the issues that are being raised and then proceed with the plea taking. I reiterate the prayer made, my Lord, that you be pleased. And this is the procedure, my Lord, to dispose of the application before you, and the rest will follow.
My Lord, I would like to say a few things, but first to tell my learned DPP, Mr. Jatiko, with the right know that he has no duty in law to oppose every application made on this side, especially if it is procedural.
Lord, I think this is procedural. No one is opposed to any. No one.
We agree, my lord.
It is a matter which is the same defense is placing it before the court. We have not known. So to say that we are opposing.
Let me finish why I said we are opposing. We are seeking for the court to halt the process until the stay application is heard. But Mr. Jatiko says, hear the plea first. That's what I heard you say. Unless he said that the plea should be heard. Unless if I misheard him, that is where I'm coming from. That in essence is opposing the stay, because once the plea is heard, the proceedings will have commenced. The very proceedings we are trying to stay. And this is a procedural matter. There is an application which is going to be served at the end of the day. And on a matter, like my learned friend Arias Bukwago, the Lord Mayor has elaborated, it's on matters that have been canvassed before this court, so it's not on any new matter. So I would like to refer the court to Article 28, subsection 1 of the Constitution, about the right to a fair, speedy, public hearing before, these are the two operative words, independent and impartial court. if I may live there. That is the area the accused persons are contending. They want their petition before the High Court to agree with them, or disagree for that matter, their contention that they are not before a fair, an independent and impartial court. They have given their reasons. So this is an Article 28 fair hearing issue, and therefore the stay of proceedings is critical to that extent. We would pray, as has been canvassed by my colleagues, that these proceedings should not continue until you dispose of the stay application.
My Lord, we pray to have that statement expanded from the record. But it's important to just make sure that we have a guided procedure so that we don't have to respond to each and everything, my Lord.
Yes, that the petition before the High Court is to determine these issues, because the recusal was about impartiality. The reference to the court, which the court rejected, was also about the same issues. So the gist of the application, that is what is before the court for trial. I would also say it's already been canvassed that asking for 1 month is unreasonable. And I would like the court to note that although they are asking we go for plea, committal was in May this year. We objected because we had an application for mandatory bail on that day. But nevertheless, since the date of committal, we have not been served with any burdens to be aware of even what we are pleading to, even if it were to come to that. So if my learned colleagues are in such a hurry to go where, when even the burdens are not with us? Because if it was the hurry for the hearing, and they should, because the trial should be speedy, to show that they are keeping to their lane and within the law, by now, without us asking, the burdens should be with us, so that the accused are even able to know what they are being asked to plead to. So I'm just asking the court to note those viewpoints, and to also reminding the court, needlessly though, that even at this court, at this chance, on your own motion, you could initiate admitting the accused persons to bail. It's within your powers. Yes. Especially after knowing that they are now been behind bars for 1 year. We are going to 1 year, 1 month. So even as we canvass all this, it is within your powers, my Lord, to admit them to bail, especially because the sureties are before you.
My Lord, for the record, Counsel Simon, for A3. My Lord, the petition before the Constitutional Court, as highlighted by Senior Counsel Ernest Kalibala, soundly speaks about impartiality, as stipulated in Article 28 of the Constitution. My Lord, this greatly impacts on A3 as well. In that regard, A3 wholesomely does associate with the prayers of counsel for A1 and A2. And my Lord, when you are pleased, we shall use the time you are going to grant to serve any further documents to the state response. We so pray.
No, my lord. My lord, my land senior colleague attempt was stating that we have no, we should, like we are opposing the application. And I was saying that we have not even reached there. We can't even be said not to be opposing or not.
Since we have not yet been served. I got you correctly. Now we are analyzing whether to take it or whether to fix the other.
My lord, and that is what we are insisting.
So what I will say is that we proceed with other than
My lord, our prayer is that we proceed for plea taking. Yeah, and then formal applications can be filed because the defense seems to be attempting to start to argue what the application is, which the prosecution has no knowledge about. My land friend, senior colleague Lukwago, said that the prosecution is lazy and they should have looked at ICMIS. But this is so absurd because this is a new matter that has not even been served on the prosecution. It is a new matter before the court. It is not even signed. It's not even signed. So we are not tagged to this new matter, which is not even before the court. So what business do we have looking at ICMIS on a new matter which we have no idea about? I believe this is very absurd from my land friend. And in addition, the defense appears to be praying for a stay before the stay of application is had, which is wrong. And to say that when somebody has taken plea, it means the hearing has started. My lord, with due respect, a stay of proceedings can happen at any stage. It doesn't have to be that because the matter has started at plea taking. No. So, my lord, this court should proceed to pronounce itself.
what my colleague was saying. I think my senior colleague, Elias Lukwago, the Lord Mayor, is not a Gen Z. But issues to do with IT operate in a different way. The procedure of ECMIS, which my senior colleague is submitting as if he's an expert, you have to be linked to that particular matter before you actually access it. He knows very well that we have Data Protection and Privacy Act. These are not matters for everyone. So this application, which we haven't even looked at, we don't know whether it was even filed. We cannot. Also, Brian wants to be taken to IT class. You see, this is what we are talking about, that we have not accessed that, and we have no business. We have a lot of things to do other than looking at ICMIS, where we are not actually linked to. Because whatever, if you have an ICMIS account, whatever you're supposed to see, whatever is linked to you is what you see. You don't see what has not been actually linked to you. I don't know whether my senior colleague has evidence that DPP's office was linked to this application. I just wanted to say that and waited our earlier submissions.
I think the matter before court, I understand it. It's a simple one. I'm sorry if you speak. There's an application. There's an application number 814 of 2025. When we came to court this morning, had not been endorsed by the registrar. Now it has been. What is missing is a date so that it can be signed. A very simple prayer from my colleague, Mr. Kanibala, was for court to kindly agree to fix it so that we can effect service. I would want to assume that the court will seek the indulgence of this court to fix it. I'm sorry, the word might be directly, but shouldn't be. My lord, the court is kindly obliged to fix it during the proceedings today. We can effect service on our colleagues because they are principal officers, so that we save time. That is the second request is that in light of what is in the application and the petition, that court is minded have the application disposed of and then we return to criminal session case number 355. So, my lord, before this court is an application which is pending the date. Which we ask my lord that it dispose of in the interest of justice. And then we return. My lord, the application does not seek to nullify the criminal case. There is no such procedure. So there is no danger, there is no prejudice to the criminal case if the application is. My lord, that's our simple prayer. My lord, that's the final submission. The one.
The final submission from our side, but just to set the record straight, because some matters have been put on record. My lord, regarding the purpose of ICMIS, it's important. It's important not only for the parties before you, but for all court users. The purpose of ICMIS, my lord, was to ease the process of managing biddings. My lord, ICMIS has never been intended for experts or IT experts only. And I want to go on record, my Lord, yes, I'm not an expert in IT, but I am one of the beneficiaries of ICMIS because I'm a court user. All court users. Actually, I'm a court officer, not even a court user. I'm a court officer. That is one, too, my Lord, and it's also important. One needs not to be linked to the server, but to the case. And I'm sure in this particular matter, the main session case from which the application arises is on ICMIS, and the prosecution is linked. So whatever pleading that arises out of the main session case is brought to the attention of the prosecution before even service is effected. That is the notification I was talking. And I was asking them to be honest enough to tell this honorable court that they received the notification, which they ignored. It's not practically possible that a session case is uploaded on the ICMIS and the application filed there is not brought to their attention. It's not possible. Otherwise, my Lord, I want to sum it up. They want to impeach the validity of the pleadings on ICMIS. That's what they are seeking to do. But unless one gets physical service, they can come and claim ignorance about the matter. And that is a very serious one regarding administration of justice. The last one, my Lord, is the danger we talked about. We have not talked about Article 44. In all this we have discussed here. That should the plea taking proceed to amount to violation of not only Article 28, but also Article 44, which is non-derogatory. Rather, non-derogable, sorry. Article 44, which is non-derogable. I'm sorry, my Lord. And that should be instructive. Now, this is the very final one, my Lord, from the application. I beg to move.
Let me ask this.
Solve this is that urgent applications are not given the same time for responses as ordinary applications. And when it is urgent, already, you see, it's a formal application.
I agree.
And the right to fair hearing is cuts both ways. So their response on record is necessary, but the request for time.
No, that one I'm going there having.
So I'm saying, in considering the request for how long, it's the urgency of the application. And in our case, we are saying,
you are not
yes, yeah, but I'm also telling the court and the defense to remember that gentlemen who are presumed innocent, three of them, yes, look, it's a part of it. It's part of it.
Also, you are saying it's not fair. It's not a ruling, by the way.
Yeah.
But I am concerned.
My Lord, I would concur with senior counsel because
Thank
if
you.
they are not prepared to proceed, now what of us who have not even seen the are prepared?
We don't know about fairness. It's okay now. We can't be the ones. So it's okay now.
They need to
Let me ask this. And the state, what is your view? Assuming we proceed now, where are they? And we leave the application. Is it fair? Or still you say the judge is not fair? Assuming, because now we are struggling on when to file a reply, when to file a rejoinder, when assuming you act the application, because we came here for hearing of pre-taking, isn't it?
Yeah.
Assuming we agree now,
Yeah.
with application, urging, they respond orally. And we leave this business of is it fair to most of you? I don't know. No, I want us to agree. So that we had come here for hearing that it's okay. But now I am saying that you are taking this one once here, this date. I don't know.
I think, my Lord, the way to solve this is that urgent applications are not given the same time for responses as ordinary applications. And
So
when
you are
it
not
is
comfortable
urgent,
to proceed with it temporarily.
orally, you see, it's a formal application.
I agree.
And
But
the right,
scratch your mind.
the right to fair hearing is cuts both ways. So their response on record is necessary. But the request for time,
No, that one I'm going there having.
so I'm saying, in considering the request for how long, it's the urgency of the application. And in our case, we are saying,
you are saying you are not couldn't be fair to proceed.
yes, yeah, but I'm also telling the court and the defense to remember that gentlemen who are presumed innocent,
That one is okay.
three of them,
Let
they
us
are-
really separate.
yes, it's a part of
Separate
it.
the process.
It's part of it.
That also you know you are saying you are it's not fair. The same. But it's not a ruling, by the way.
Is it? Yeah.
But I am concerned. Before I go to
My Lord, I would concur with senior counsel because
Thank
if
you.
they are not prepared to proceed, now what of us who have not even seen the manifesto? We are prepared.
we don't about that. It's okay now. We can't be one. So it's okay now. That's why.
They need to fight to shorten the time.
I've decided to give each party 1 week, including court. Therefore, 1 week will operate as follows. The prosecution should be served today, which is the first. And then, when they are served today, 1 week from today, file your reply. And this takes us, 1 week takes the prosecution on 11th December, file and serve. And then we're going, I think, I've given it also 1 week. That is 18th December. And finally, we come here to add this application on 22nd December today. The remaining case also is fixed for mention now when we are on 22nd of this month. Okay. Now, there is
Date for plea taking, but yesterday the defense lawyers filed a constitutional application because we were dissatisfied with the refusal of the judge, Justice Baguma, to recuse himself, and also his refusal to refer the question of his recusal to the Constitutional Court. That's when the last time we were here. So yesterday, an application was filed framing several constitutional issues to the court, among them the right to fair trial before an independent and impartial court. This is because the accused persons, our clients, do not believe that they will get fair trial by an independent tribunal or court before Justice Baguma. So having filed that constitutional application, a second application to stay the proceedings so that Justice Baguma's court should wait for the outcome of the Constitutional Court before proceeding with the case. So today we were telling the court, do not take the plea, stay all proceedings until we come back from the Constitutional Court. The court agreed with us that the stay application should be heard first. He has given us a date for hearing. That date is 22nd of December. The prosecution has been given up to the 11th to file their replies because we had not served them, they were being served today. And we have up to the 18th to make any rejoinder, and then 22nd will be heard. But today we have also reminded the court, even with all those applications, the court still retains its jurisdiction on matters of bail, and the court can actually release the accused persons or admit them to bail on its own motion, especially noting that they have been in custody now for more than 1 year and their case has not commenced. We've also noted that the prosecution has not given us committal documents that were committed in May. And up to today, December the 4th, we do not have a committal bundle. So our clients do not even know what they are being asked to plead to, knowing it's charges of treason, but not knowing what evidence or acts they are alleged to have committed means they are being asked to plead to what they do not know. So we are coming on 22nd for hearing of the application of stay. There is also a bail application pending, and in the application for stay, we are also asking for bail. But we want stay granted, and we'll keep reminding the court it can, on its own motion, admit them to bail. They have all the documents, they have the sureties, and they know what we said in the previous applications.
Okola kibayita okugubasomera kimuteekeddwa okumanya wa public kyeteekeddwa okumanya Dr. Besigye n'Obedi Lutale okuva lwe baleetebwa mu kooti wano oba olubakola komite olubagamba lwe bakola komite nga 29 omwezi ogwokutaano tebasomerwanga mu busango mu butongole. Omuntu yenna ng'avudde magistrate court bw'ajja mu kooti eya waggulu bamusomera gye bayita indictment omusango tebagusomeranga naye olwaleero babadde bategese nti bagubasomere bababuulire omusango gwe bavunaanibwa. Kibadde tekinnakolebwa, ffe tukyemulugunya nti kooti ya mukulu Baguma teri mu bwenkanya era abantu baffe Dr. Besigye n'Obedi Lutale bazze bakyogera lunye si beeteefuteefu kuwozesebwa mu maaso ga mwami Baguma era n'omusango tebaagala gusomebwe maaso ga Baguma. Era n'olwaleero tuzze nga tuli bamalirivu gamba omusango tegusomebwa, kyekyatututte mu kooti etaputa ssemateeka ne tuteekayo okusaba kwaffe kubanga emiwaatwa gyonna gye tubadde tuyitamu wano muga nti owaayo omusango guveemu n'agaana. Ne tumugamba ky'oba oddako nno kale oba ogaanye oguvaamu guweereze mu kooti etaputa ssemateeka fayiro yaffe kooti nayo eyongere okutundira ku nsonga ez'obwenkanya oba ddala wanaabeerawo obwetengerevu bwa kooti nga atika eya 28 n'eya4 bwe zoogera. Justice Baguma era n'agaana. Kati ekkubo lye tubadde tusigaza limu lya kufayiringa constitutional petition eyateereddwayo olunaku lwajjo ne tuteekamu n'application esaba nti nga kooti etaputa ssemateeka egenda maaso n'okuwuliriza petition eyo mukulu Baguma agira ayimiriza mu bibye. Olwaleero kye tutunuulidde application eyo agitaddeyo nga ennaku z'omwezi 22 lw'ejja state ezeegamba bo badde bannagimanyaako ne babawa paka ennaku z'omwezi 10 babe nga pamini 11 bateekemu okuwoza kwabwe then naffe tuddemu nga 18 nga 22 tukomewo wano tutandike okuwulira application eyo oba Baguma Justice Baguma ayimiriza okugenda maaso n'okusomera Dr. Besigye omusango nga bwe tulinda ati kooti etaputa ssemateeka emala okusalawo oba nedda. Ekyokubiri kwe kuba nti n'ebbeeyi bwe baweebwe bamaze omwaka mulamba kati kumpi n'omwezi gumu nga bali ku rumandi nga temusango gwabwe teguwulirwa ate nga balina eddembe lyabwe okuyimirirwa abajulizi bonna baweebwayo na buli kimu kyonna bakituukiriza ekyetaagisa so nga tugamba ne ku olwo era tujja kusaba Dr. Besigye n'Obed Lutale beeyimirirwe naye ne kino tekirekeka olunaku lwajjo omwami Museveni yalonze Tukakyungulwa Richard nga chairman wa General Court Martial mumanyi bulungi Tukakyungulwa kye yatukola mu General Court Martial nkoko baana baayo yatuuka n'ajungulula balooya bonna yajungulula senior counsel omanyi yatuuka n'omugamba nti ono foreigner webweru tamumanyi tayinza ndala kuwolereza mu kooti eno n'atuuka nagagwe Martha Karua nsobola n'okukwatira mu kooti yange imagine eri yalinga advisor judge advocate abanga advisor awabula kooti naye ng'obuyinza bwalaga maama kati kyewunyisa oba yalaganga obuyinja amaanyi ago nga advisor nga judge advocate ne kati bwe wataddewo ddala ye ssenkagale wa kooti akulira abalamuzi abalala 9 bali 10 kigenda okuba mu General Court Martial kigenda kuba kifumba mutu naye naffe tufunvubidde era tugenda mu maaso n'okulwanyisa kooti ya Tukakyungulwa kuba tumanyi lwaki bagireetedde mu kaseera kano ng'ebikolwa by'okutulugunya abantu bigenda mu maaso ab'opposition abantu bangi bakubibwa tiyagaasi alinga tiyaga kuba emiggo okutinga okuba emiggo okubuzibwawo kw'abantu bateeka simanya mu fridge kugenda mu maaso kaakati tulina n'okutya nti nabono basobola okukira bati ne bagira bati bino ebintu byabano teweewuunya nga kifayiro bakisituddewo wano bakijjewo Baguma nga bakizizaayo mu General Court Martial kubanga yali yafa kati bagizuukusizza nga bakitadde eri nga baga fayiro kati eri wa Tukakyungulwa nga batugamba tudde mujjukire gye baasibira ero nikiiza so luno olutalo lwakufa na kuwona era ffe tugenda maaso n'okugamba bannaffe ffenna bwe tuli mu mbeera enyegerezebwa abali ku sayidi eyagala enkyukakyuka nti luno lwo yalwa mu nnyindo tulina kulwanira wamu okulaba nga tujjako embeera eno Tukakyungulwa teyazze kusiba bamenyi b'amateeka yazze kulwanyisa babyabufuzi abaagala enkyukakyuka mu ggwanga mwebale nnyo mwebale.
I'm shocked to hear that the gentleman who was the judge advocate during the trial of Dr. Kizza Besigye and Obed Lutale at the Machindie General Court Martial is now the chairman of the court. He, a lawyer, was present and didn't seem to see anything wrong with the orderlies of the court assaulting an advocate, Aaron Kizza, who had come to do duty. To hear now he is the chairman. If an advocate could be assaulted while he sat there and he did not advise the court martial, and that he is chairman, I actually pity anybody who appears before that court martial.
Used as a tool of persecution against political opponents. We had succeeded in bringing it to an end through that protracted litigation which went up to the Supreme Court. But unfortunately now they have resuscitated it. It's a reincarnation now, and now in a more lethal form, because Tukakyungulwa is worse than Freeman Mugabe. Even when he was still just a judge advocate, he reigned supreme in that court. And he didn't mince words. He said his word was binding, was final. Whatever he said was final. Yet it was just an opinion given to court to take its own decision. But he would impose it on court, and you would see, actually, Freeman and his team would gladly embrace the verdict of Tukakyungulwa. So if he behaved that way as a judge advocate, now just imagine what's going to happen when he is the Supremo, when he is the presiding officer of that kangaroo court. It's going to be worse than before. And it's the reason we are determined and we are marshalling up all our efforts, the forces of change, to ensure that we bring down this tool of oppression. It's incumbent upon all of us to get together, to bury our hatchet, and bring down this tool of persecution. And that's what we are determined to do. We are worried. Anything can happen. Like this ping pong which is happening here. Anytime they can even shift this file back. Remember, there are files which were supposed to be transferred to the civilian courts. Up to now, they have not been brought here. So it would appear they are just going to reactivate those files, which had now been kept in the sheriffs, the General Court Martial. Now they reactivate it and bring people to take plea there. So the same thing can happen to Dr. Besigye, just pushing this file back and say now go back to Kachungurwa. We are saying no, and we are going to put up a spirited fight against that kangaroo court.
And that amendment of the Constitution to return the General Court Martial, my view is that it's unconstitutional. It was brought up to defeat the judgment of the Supreme Court. So there is still a moot question here. You cannot bring change of the law to defeat a judgment of the court. Yeah.
Thank you.